And I am really excited to introduce our keynote for lunch today. The laws in the United States are obviously, there's patchwork, some might call it a nightmare. It's a mess, right? Because we have federal prohibition that has been a failure for as long as it's been enacted, and we've seen it, evidence of that more and more. Especially as we're able to communicate with each other with ease of access to information and communication. And as we are able to see what the big picture looks like as we move forward away from prohibition into a regulated market, we see things happening differently in different states. And not only are the laws different, but the regulations are different. The way they're enforced are different. The consumer models are different in the way that the trends are going. And it's important for a business that wants to operate in all of these states to be very well aware of that and be adaptive. PharmaCann is a multi-state operator. They are one of the largest privately held, vertically integrated cannabis companies in the country. And they're operating in both the medical side and adult use. Again, another distinction to make on what the regulations look like. So there are a ton of moving parts, and Mayor Grashin is the General Counsel for PharmaCann, one of our platinum sponsors here for the conference. So it is my pleasure to introduce Mayor Grashin with PharmaCann.
Fritz, am I good? All right. Y'all hear me okay? Thanks, Heather, for that lovely introduction, and good afternoon, everybody. So it is my absolute pleasure to be speaking with you all about operating in multiple states amid evolving laws and regulations. And I say it's my pleasure to be speaking about it because it's a lot easier to speak about it than it actually is to do it. So my goal here is a little bit twofold. I want to give everybody a little bit of a high-level overview of what the state and federal legislative and regulatory environment looks like. And I want to zoom into the practical applications for what that means for running a plant-touching cannabis company like ours or like many of the people in the room today. My hope is that by zooming in a little bit and then zooming out, I'm going to give everybody a little bit of a clearer picture about what the reality is and how it actually works. So I'm going to do my best to leave some time for questions at the end. If not, I'm not too hard to find. I got business cards here. You can find me on LinkedIn or the like. So to start, what I want to do is give you a little bit of context. Like, what does this mean to be a multi-state operator? And what does that mean to be a lawyer at a multi-state operator? So I'll give you a little bit of context about me, just to understand where I'm coming from and my perspective that I bring. So I've been practicing attorney now for 13 years. I've operated in a variety of different industries and practice types. I started as a clerk for a bankruptcy judge right out of law school. I went to private practice, worked at some fairly large law firms in litigation. So I've got a litigation background. And then I went in-house where I became the company attorney for a company in the automotive tech industry. So I've seen sort of a variety of different ways that laws get interpreted and the like. Now that I'm a lawyer in cannabis, and I've been here for going on about 2 years now, I've realized a few things. So one is that being a lawyer in cannabis, it's like being a lawyer in any other industry, but it's a lot harder. It's a lot more complicated. It's also a lot more fun because there's not usually an answer for a lot of these things. There's rarely precedent that you can rely on. And so you're kind of always trying to figure this out and make things up and do cost benefit analysis and like, well, it's kind of legal or it's almost legal, but we should be fine. And nobody really knows. So let's do what we can and be as careful as possible. The way that I think about this really is when you're a lawyer in cannabis, or really when you're anyone in cannabis, and I'm focusing on the lawyer part, is you need to keep your cannabis lenses on. So everything that you're doing, you've got to look through that cannabis lens because it really impacts absolutely everything that you do in a cannabis company. And that's true if you're a frontline dispensary employee. If you're a retail employee, cannabis regulations apply to absolutely everything you do. It could take you 2 or 3 months from your hire date to actually get started because there's background checks. There's state badging offices. I will tell you right now in Illinois, it takes about 2 months to get your badge. Pennsylvania, it takes them so long to get your badge right now. They just say, just start working. It's a provisional. We'll let you start until it actually comes through. So it implies everything they do. You know, if you get a Gap employee who's used to accepting a pair of jeans as a return and then just taking and putting it in the back of house, that doesn't work in cannabis. There's regulations that cover refunds, that cover any of these product issues. You got to be careful about that. Researchers, for our scientists, R&D, the restrictions there are legion, right? You can't sit there, you're like, oh, I want to mess with my formulation and make this taste a little bit better. There's regulations for that. Could take you months. You can't taste them if you're in a medical market. So you have no idea how something's going out and launching. I mean, it's impossible, let alone the actual cannabis and the cannabinoid components of that, how difficult it is. You have to lock everything up at night. You only can take out the specific things. Everything you're doing is being watched by video. Challenging. To say the least. HR, forget about it. I mean, it's the hiring practices, everything slowed down, the benefits you can offer for people. It just makes it really, really difficult to provide the kind of career tracks and the career trajectories that we would hope in an industry that frankly is only growing. So a little bit of complexity. So why me? Of all the lawyers that call themselves cannabis lawyers, distinct from the lawyers that are actually cannabis lawyers. For those who have worked with them, you know what I'm talking about here. Like, why am I the person in the position to talk to you? It's not because of me. It's not like I'm anything special. It's because I work for a company, PharmaCann, who's been around now in operations for over 7 years. They started 8 years ago, and they have been navigating all of this. And so the idea is I'm kind of standing on the shoulders of giants here. I'm standing on people who have been in the legal industry for almost as long as there's been a legal industry in these states. And we've learned a lot of lessons along those ways. And so I'm here to try to do what I can to impart some of that. So what is PharmaCann? There we go. PharmaCann. So we started in 2014 in Illinois. And our catchphrase, improving people's lives through cannabis. We've since grown tremendously from that. So we were founded in 2014 by a team of biochemistry researchers, and we began looking into this in medical-only markets at the time for these cannabinoid-based therapies in the highly regulated and early medical states of Illinois and New York. We were among the first license holders in both of those states. As some of my colleagues never tire of mentioning, we're the highest scoring application in New York. So very excited about that. We still hear about that years later. We currently have 27 licensed healthcare practitioners on our staff and over 1.2 million unique medical cannabis dispensing transactions. So we've got this ability, we've scaled, and we've got a sophistication that we've been able to bring to this process that I think gives us some unique insights here. One of the things that I think is really interesting about us too, as opposed to some of the other large operators, is that we've grown predominantly through the application process, not through acquisitions, but actually through competitive applications. We bring a very sophisticated, as Heather was mentioning, a vertical integration. But what that vertical integration here means is it's more than just the supply chain, but we also have R&D. We also have very talented scientists on our team. We're constantly looking for new products, constantly trying to dial in efficacy, consumer preferences, and we're taking this all into account. And we do most of this research in-house. There we go. Vertical integration. Again, we cultivate, we have processing. In all of our 8 states, we're vertically integrated. All of our states, we have cultivation, we have dispensaries, and we have processing in all of them. So today, as of last Monday, we are currently in 8 states. We've got about 8 acres of cultivation capacity for cannabis. We've got approximately 50 retail dispensaries and about 200,000 pounds of flower grown every year. As you can see, a lot of these states here. So we've got Illinois, New York soon, Massachusetts, Michigan, Colorado are all adult use. The remaining 4 states are still medical only. And all of our legacy states, so including Illinois and Massachusetts, we were in those states when those were medical only. So we've really had this opportunity to kind of grow with the industry, make those transitions from medical to adult use. And I think we've learned a tremendous along the way. So as I said, the reason why I'm sharing this is so that when I talk about the rest of the presentation now, when I talk about the legislative framework, what that means, I want you to understand that we've really at this point kind of seen it all, right? We've grown, we've expanded, we've been able to adapt. And so I'm hoping that what I'm able to tell you, you understand kind of the perspective that we're bringing and help adapt it and use it in your businesses as you go forward. So with that, let's talk about the federal legal landscape. And get it, that's a landscape on that picture? Come on, I thought that was funny. My wife did not, but she helped me do it. So it's her fault. So federal legal landscape. So I want to talk a little bit about how this goes, right? And before I get into this, one kind of, I think, important caveat for everybody here. I am the lawyer on the team, or one of the lawyers on the team. And what that means, I'm the lawyer that is brought in to get stuff done, right? We've negotiated a deal. Let's get that on paper. Let's formalize it. We get sued. Let's defend it. Somebody's screwing us over. Let's bring that lawsuit. So I'm a day-to-day, just strategic, but a day-to-day kind of guy. Like my job is to make this stuff happen. What does that mean? I'm not a legal scholar. I don't pretend to be a legal scholar. I'm an advocate only by accident, right? Because I truly believe in the normalization, the destigmatization of cannabis and how this is important. I mean, I've seen it in my own life. I have a brother with Crohn's disease and cannabis has been a huge help for him and all these things. So I truly believe in it. And I believe that in a professionalization of the industry, in this normalization, that's one of many avenues that we have to take to do this. But I say that I'm not an advocate because I'm not the person who's going into state houses or the Capitol and arguing about the way that the rules should be. I live in the world that we have right now. And so I want you to take all that in. When I'm talking about different methods and different strategies, I'm not talking about the way I wish things were, but in the actual reality. So don't, if I say something and you're like, well, there's a better way, I probably agree with you, but that's not where we're at right now. So federal legal landscape. I suspect everybody knows federally illegal, right? That this is a illegal substance according to the federal government. Yeah, I know, right? It's such a bummer. And but that's the reality we're dealing with, right? And so I have a question for you. Do people know, like, why do we care that it's federally illegal, right? We all, probably a lot of us have been to Colorado, California, and you go there and it sure doesn't seem illegal, right? You've got plenty of street corner stores where you can go and you can buy stuff. There's dispensaries all over the country right now. Texas has at least some limited capacity to get the cannabis. So why do we care that it's federally legal? Well, that is a little clause in the Constitution called the Supremacy Clause. Won't talk about this too much, but the idea is this Constitution and the laws of the United States, that means federal laws in this context, and the laws passed shall be the supreme law of the land. Now, what that means in practicality is that federal law trumps state law. So, doesn't matter if you are operating a state legal cannabis business, technically, because of the Supremacy Clause, that is still a federal crime. And I'm gonna let that sink in because it's absolutely wild, right? This huge industry is still totally criminal according to the federal government. Wild, right? Absolutely wild. So let's talk a little bit about what that federal law looks like. I also want to point out this is a really weird thing in cannabis, what's going to be coming next, because you don't really see this pretty much anywhere else where there's just this kind of hand washing a little bit. So what does it mean to be federally illegal? We've got the Controlled Substances Act, the CSA. I suspect people may be familiar with the CSA, the Controlled Substances Act. Quick background on this, passed in 1970, and within it, Congress established 5 schedules, 5 tiers of illegality or controlled nature of the substances. So Schedule 1 is the most restrictive, and It is overseen, this whole thing is overseen by the DEA, Drug Enforcement Agency, with some assists from the FDA in some places, Health and Human Services, and the like. And when they're assigning things to a schedule at the time, it was done by looking at several things, including potential and history of abuse, scientific knowledge around the effects, the likelihood of dependence, and overall risks to public health. So, Schedule 1, the most restrictive, no currently accepted medical use and a high potential for abuse. Who knows what's on Schedule 1? I think we're all fairly familiar with this. Marijuana, cannabis, heroin, LSD, ecstasy, and peyote, right? So these are the most restrictive products. These are things where you cannot get a prescription from a doctor. Research, very, very curtailed, very, very highly regulated, and really, really difficult to play with. Schedule 2, beat my punchline a little bit, high potential for abuse, potentially leading to severe dependence on it. So what's in Schedule 2, which you can get a prescription, a little bit less regulated. We've got opioids, meth, cocaine, and fentanyl. Really fun products that have some potential for, yeah, right? Like, I mean, like this is wild, right? Like the idea that cannabis is Schedule 1 with none of that, and those are Schedule 2, especially when you consider the fact that, like, last year, 75,000 overdose deaths for opioids, forget fentanyl, cocaine, all of these. How many overdose deaths from cannabis last year? Zero. How many the year before? Right. So the point being how kind of absurd this is, right? Again, I think everybody's probably aware of this, but it bears repeating here a little bit. And then Schedules 3, 4, 5, again, lower dependencies, lower risks. And if you see the way the law treats them, there's definitely a difference between the way Schedule 1 and 2 get treated in terms of regulations at the federal level and the rest. So don't need to spend too much time. So based on what I just said, for Schedule 1, Schedule 2, remembering that those are the most highly restricted. And now, remember, this is where I'm coming at this from a real world perspective, not advocacy, not a scholarship. What would be the easiest way to have the federal legislation match the reality, right? Match what we're seeing on a day-to-day basis across 48 states in the United States and just every day? I think the reschedule, right? Like descheduling is a little bit more difficult perhaps, but rescheduling makes the most sense, right? Like, let's be honest, you know, this looks like not a bad idea. Like cough suppressants with low level of codeine, yeah, I could see cannabis, you know, not too dissimilar perhaps for that. Low potential, yeah, kind of makes sense to fit it there. Well, here's the problem. There's a mechanism for rescheduling, but the mechanism here gets us into this chicken and egg loop here that's at this point almost impossible to escape. So to reschedule something, there's a formal process for this, right? It makes sense. Well, how do you do it? You do your research. And your research says that if you could get evidence of the pharmacological effects of the substance, current scientific knowledge, risk to public health, potential for liability, or if it's a precursor, then you can establish all these, you can do your studies, and now you can reschedule it into something a little bit more sane. What's the problem? The problem is a Scheduled 1 drug. I see nodding here. People have ran into this before. The problem is a Schedule 1 drug. It's damn near impossible to get actual federal funding or even just federally authorized studies. I mean, in fact, it's been crazy. For the last 50 years, any study that was authorized by the DEA to study cannabis came out of one site in the University of Mississippi. Now, not to dog University of Mississippi. I'm sure they're wonderful people and they do what they can down there. But why are people laughing? Is anybody? I have no interaction with them. I'm sure they're great. It was like that wasn't sarcastic. But the problem is you've got this monopoly on this, and you've got people that are growing cannabis that have, well, how long ago did Mississippi get even a medical program, right? There are people that are growing cannabis that bears very, very, very little relation to the actual real world cannabis that people are using for medical purposes, that people are consuming. And so they've got this issue where it's impossibly tightly regulated, and the cannabis that is being studied in these studies doesn't look like the cannabis that that patients and consumers are using every day. One of the quotes, one of the things that I've seen recently was the idea that what they were getting was so sort of weak and didn't reflect reality that they weren't able to distinguish between using the medical cannabis provided by University of Mississippi and a placebo. So for all the scientists now, I mean, it's right. This isn't good science right now. And so we're stuck in this situation right now where it's Schedule I, all these limits, and there's this impossible feedback loop that you get stuck in and no real opportunity to escape and swing. Yeah. And this is why, it's an excellent question. I mean, you get that, and then you get the differences between, like, it sort of echoes that some of the hemp issues too, right? Where you've kind of got hemp now all of a sudden is just outside of a regulatory framework, and there's no real way. This is why I had my preface where I am not an advocate or a theoretician here, right? Like, I have to deal with with what I've got in front of me right now, because I think that I think you're absolutely right. Like, if we sat here, we could spend the rest of the day talking about the inconsistencies and these impossible to escape loops. I don't have a good answer for that at all. And now I have colleagues that I think have put a lot of thought into that, but you know, no, I'm absolutely. I mean, Heather, I bet you can introduce to some people that have been thinking about that, huh? You know, some people. And you know, I mean, there are lots and lots of from think tanks to on the ground advocacy thinking through that. Does anybody help her afterwards and get some answers? I'd be curious to hear that too. Okay, so what do we have right now, right? We've got this issue where let's quick kind of check on where we're at. So we've got supremacy clause. So federal law trumps state law. We've got federal law that this is illegal and it looks like it's going to stay illegal. I didn't mention there's a legislative fix as well to rescheduling. Congress could come in and at the stroke of a bill passage, reschedule it. Not an advocate. Seems, given what we've been seeing, not the most likely outcome. There was some talk that President Biden executive order it, dubious whether that would work or not. But there is that system. But again, it's unusable. Okay, so anyways, apologies. I am a total nerd on this stuff, so I can keep going. So I'll try to. That's why I wrote this down. Otherwise, I'll just keep going. So again, supremacy trumps state law. So how the hell am I not in federal penitentiary, right? Like, why am I not in jail? Why are many of us not in jail? Why does PharmaCann exist? Why is PharmaCann growing? Why do I have a website? Why am I proud to work where I work? Well, this, I see some people nodding. I think they anticipate where I'm going with this. It is the Cole Memorandum. So the Cole Memorandum, we've got this dark and scary path about federal illegality. How do you stay out of jail? 2013, Obama's Department of Justice, the Cole Memorandum was discussed yesterday a fair amount. And the idea was that effectively the Department of Justice, federal law enforcement, has said that they are reserved the right to go after state compliant cannabis, but that broadly speaking, they'll be exercising their discretion and they will deprioritize going after state compliant cannabis companies and trades, so long as they follow the rules that are consistent with the Department of Justice principles. So what are those principles? Things that we probably all almost take for granted. Preventing access to minors, the proceeds of marijuana don't go to criminal enterprises or cartels, no diversion to other states. That's a big one. That's gonna probably the main theme of this whole thing kind of comes down to that aspect of it. Don't use as a pretext for other illegal activity. No violence, use of firearms and furtherance of operations. No drugs, driving, and other public health consequences. And no operating on public lands or federal property. So don't go to a national park with your cannabis. Don't go to an airport with your cannabis in theory. But so long as you're doing this and in conduct that is compliance with the state laws permitting the cannabis operations, are less likely to threaten the federal priorities set forth above. Pretty mealy-mouthed statement, right? There's a lot of ambiguity. There's a lot of room for them to change things. But so far, so good, right? It's the first time where there was a kind of coherent policy put forth, as far as I understand it. Now, the one other thing I want to point out too is the Cole Memorandum had sort of a companion piece for financial service providers. There's the FinCEN guidance, the financial crimes enforcement network, and it effectively said that banks and service providers, financial service providers, can provide these financial services to state compliant cannabis operations so long as they do their diligence and they follow along. So now Cole Memorandum, looks good, not great, but of course, 2013, and then under President Trump, Attorney General Jeff Sessions, one of his earlier actions is he rescinds the Cole Memorandum. Cole Memorandum goes away in theory. I think there are a lot of people that freaked out a little bit, right? Understandably, is the federal government now going to come after me? I've come above board. I've been relying on this. Now all of a sudden it's gone. So what happens? So Attorney General Jeff Sessions rescinds it. Attorney General Barr under Trump keeps it rescinded. Merrick Garland doesn't do anything to bring it back under Biden either. So we've been operating under a 2013 memorandum that hasn't been in place for what I think 5 years at this point. Absolutely wild. And yet, we've seen there's various other things going on. There's no budget for it right now. I don't want to get all the chicanery that's going on, but in theory, this is kind of scary. I think at this point we're pretty robust. So the idea from all of this is right now, we're kind of hanging on by a little bit of a thread. And to me, what that means is we've got to do what we can to keep our nose clean, to pay our taxes, to treat our employees properly. Yeah, we'll get to taxes. Don't get me wrong. That's a whole separate issue. I'm not saying overpay your taxes, but pay our taxes. Treat people right. Don't operate as upstanding citizens because we're on a little bit of the knife edge here. So if we've got all this right, and we've got the Cole Memorandum, let's pretend it's still in place because everybody pretends it's still in place because otherwise we wouldn't be able to sleep at night. So let's pretend it's still in place. So if we got the Cole Memorandum, let's go back to my original question. Why do we care about federal illegality? This is the great state of Texas. What do we care about what they're doing in Washington, D.C. right now? Well, unfortunately, maybe not we, I of course care. I'm a lawyer. I of course care what's going on. But what's the issue? What's the practical implication then for that federal illegality that we have? Well, this is where we get to some of the scary parts of the federal system and really some of these roadblocks that we face as a company and as an industry generally. So one of the big issues that we've got right now is because there's no law allowing financial services to serve us, they've got the FinCEN memo and the rest, financial service providers tend to be extremely risk averse. And so what does that mean? What does that risk aversion mean in practicality? That risk aversion means that it's really hard to get a bank account. It's really hard to be able to process your payments. We are still a largely cash business. I don't know of any other cash businesses, legal cash businesses that are still out there. So, trucks of money, all sorts of operational concerns. And so there's been lots of movement to try to do this. And safe banking, that FinCEN memo that I was talking about, safe banking was trying to enshrine that in the law. And it was trying to give financial service providers that protection that so long as you operate with state compliant banks, you're going to be okay. So far, it's passed the House of Representatives 6 times. Pretty great, including pretty recently. Yeah, how's it done in the Senate? Yeah, no, not even getting a hearing in the Senate. So we're still stuck with this where you can't do it. And as a small business, I can't even imagine, right? You can't get a business credit card. How do small business get started? If you don't have wealthy friends and family, you get a small business loan. Yeah, no. You get a credit card? No. All of this. So this federal limitation, this federal illegality really hampers the ability to grow. And it creates massive security issues. I trust you're all aware of the rash of robberies that we're seeing now in California. We're starting to see in Illinois. We're seeing it in Colorado because people know where's a good place to get cash? Dispensaries right now. And so it's a huge challenge. Even in a company like mine, where we are able to find bank accounts and the like, let me tell you what it's like if you need to get a wire transfer out, if you need to open in a new state. It is months, and it is a lot of money to get that done. I was talking to somebody yesterday, a small group of investors and growers, and they were telling me that one of their team was finally able to get a bank account open for a couple $1,000s, I think $10,000 or something like that, $250 a month for the privilege of parking their money in there. I mean, that's cost prohibitive, right? You can't operate along those lines. All right, I think the next one, not as big of a deal, federal illegality, but one of these examples of those cannabis lenses, and it's intellectual property. I mean, trademark, right? Let's say you're starting your own brand. You've got your premium cannabis flowers, your Mayer company, and you've got your strains, and you want to go out, you want to make sure nobody else is going to take your trademark and that they're going to do this, right? Like in any other business, you go and you get it trademarked. Well, guess what? You can't trademark cannabis because there's no category for that at the USPTO. So this is a fun one though. There actually is a workaround for this. So you go, you put on a t-shirt. Oh, no, I'm trademarking apparel with this name, and you do all this. So there's all sorts of these fun workarounds. I'm not even gonna get into patent because I find it incredibly complicated, confusing. I barely understand it, so I'll do that. So intellectual property, kind of a weird one. Now, taxes. I saw a lot of nodding heads for that. This is, I think, perhaps one of the biggest things, and the people that are not in the industry have no concept of. People trying to get into the industry, you need to know this. So if you sleep through the rest of it, please pay attention to this next conversation. All right. First, a little bit of quiz break. Who knows how Al Capone was finally brought down by the FBI? Taxes, tax evasion, right? An early test case for the principle that you need to pay income tax on your ill-gotten gains. Wasn't bootlegging, wasn't murder, it was taxes. Send him to Alcatraz. So with that in mind, a quick history of 280E. 280E, 1974, an individual in the fine state of Minnesota was arrested, convicted with narcotics dealing, right? He was a regional distributor for, I think it was meth, cocaine, and cannabis in 1974. So went down, but despite his pastimes or the nature of his career, he was a law-abiding citizen otherwise, and he, of course, paid his taxes, as any good Minnesotan does. Now, the issue that came up there, and this went up and down the courts on appeals, is he went and he deducted his business expenses. He deducted his office rent, the mileage that he traveled, because, right, Minnesota wasn't getting grown there, and it wasn't getting produced there. So he had some airfare that he was trying to deduct, like any normal small businessman does. You deduct the costs of doing business. Well, 1981, the appellate court, the Court of Appeals, upholds those deductions. They say, yeah, he's paying his taxes. He could deduct like anybody else. Well, 1981, war of drugs was kind of a thing then. And so Congress was like, oh, we can't have this happen. No fair. The rules can't apply to everybody. So we need a special rule here. And they passed 26 U.S. Code 280E, expenditures in connection with the illegal sale of drugs. And under this lovely provision, no deduction or credit for any trade or business if it consists of trafficking in controlled substances, Schedule 1 and 2 of the CSA. Back to that conversation earlier, if you are a cannabis business and you have $100 of revenue, if you're a normal business, you have expenses, right? You deduct those expenses. $100 of revenue, let's say you got $70 of expenses, $30 decent profit margin, you pay taxes on $30. If you're in cannabis, with some exceptions, you're basically paying it on that full $100. So you're paying, there's times where you're paying more in taxes than you actually take home from your operations. There's an exception, as the IRS has talked about it. The one caveat is the cost of goods sold, your COGS. And so this helps if you're in cultivation or processing, because then you can kind of deduct the costs to maybe build your greenhouse, the soil, the fertilizer, all those things are deductible. But you know what's not? Especially if you're in a dispensary, especially from the retail side, yeah, advertising expenses, wages and salaries, right? Most of your major expenses, travel expenses, those are not deductible. So I want to leave this with everybody because I don't know, I know when I got in this, oh, everyone's rolling in cash. I'm like, no, 280E. And like, wait, what? And you start trying to explain tax code to non-cannabis people, non-lawyers, and their eyes glaze over. I'm like, no, this is really a big deal. This is a really, really big deal. So I want to make sure that everybody, if you remember nothing else, remember 280E, talk to your accountant, talk to your lawyer, and make sure you stay out of trouble, because there's been lots of people trying to creatively get around this. Most have failed, and most who haven't failed just haven't been caught yet. So would just advise being very, very, very careful. All right, so I want to take a step back and talk a little bit about where we're at right now and then where we're going to go forward in this conversation. So we established, right, this is federally illegal. And the Cole Memorandum gives that some teeth. The Supremacy Clause gives that some teeth. The Cole Memorandum says if you comply with state laws and you don't cross state lines, you're not likely to get prosecuted. And it's pretty hard to turn a profit because of 280E. So what we're left with right now is a very, very complex patchwork of regulatory systems. So that's Rise of Skywalker for any other nerds like me. And so we're left with this patchwork of things that makes it really difficult and complicated, right? We're effectively operating now in basically 50 different markets, right? We've got some that are totally illegal. We've got some that are, call it CBD or very low THC. We've got robust medical markets. And then we've also got full adult use. And you've got just this crazy patchwork of regulations where all different, right? Just because you're adult use in one state tends to look very different than another state, right? Colorado, there's no license caps. You can go in and as long as the local municipality is cool with it, you could open up a bunch of them. Illinois, you can't have more than 10 dispensaries. Massachusetts can't have more than 3 dispensaries. And that's just within the adult use market, right? Let's set aside the differences in the medical markets. So what this means is between that and not being able to cross state lines, so a company like PharmaCann, we effectively have to operate 8 different businesses, right? Our business model, our way to market, our way to comply with all this changes from state to state dramatically. And I mean, I'll give you an example. So talking about last night, this is probably my favorite cannabis product I've ever tried in the edible space. We made these in Massachusetts. There's these peanut butter pretzel caramel crunch. I can still taste it. It was amazing. So we were offering these in Massachusetts, right? I mean, we hired a team of candy makers, confectioners. Like we wanted the tastiest, the shelf stable, great effect because the fat solubility, oh, it's just delightful. So I got to try that when I was out visiting in Massachusetts. Came back, was talking to the powers that be. I'm like, so when are we getting this in Illinois? Like, this is awesome. I can't wait to introduce people to this. Said, oh, well, we can't do it in Illinois. Why can't we do it in Illinois? Well, because you need a different machinery for that to get the permission to get it in Illinois, to be able to build it out in Illinois. We'd basically have to shut down operations for a few months in order to be able to launch this production line. And it's just not practical. And that's kind of some of these difficulties that you get in going across all these ideas. So what am I trying to get at here? What I'm trying to get at right now, and I'll go into You tell me, Heather, if I got time here, but what I'm trying to get into a little bit now is some of these patchworks. And I want to bring to you some of the things that we've learned operating across these states, because I think these apply not just across states, but also within states, right? Shannon Edwards yesterday was talking about it in Texas. You've got, I think it's 254 counties, I think he said, and every single county has its own approach towards legalization, criminalization, enforcement priorities, prosecutorial discretion, and the like. And so even if you're never leaving Texas, the concepts that I'm trying to bring here, I think I hope are very relevant. And they're not just relevant if you're the lawyer like me. I was putting this together with my marketing person, and Heather, when I was talking to her, she was like, she just rolled her eyes when I told her, like, marketing, the differences that they have to do from state to state. I mean, it's absolutely crazy. So with that, I want to talk a little bit about kind of the practicalities of like what I deal with as a lawyer, because I think these are the kinds of things that everybody here in the cannabis industry will come across. Maybe not as the lawyer, but as a client, perhaps. So let's talk about just M&A, right? So we just had a big merger that came through Monday. And let me tell you something. The deal, I don't know, 2-3 months to negotiate, something like that. Getting to closing, another month or two. You know what we were waiting for since, I think it was about November, December? We were waiting for regulatory approval. We were waiting to go through the states. We know what we're doing. Our applications, we had those filed quickly. And it took the states months to get back on us. Now, why do you care? This is two big companies merging. Well, you know what is also really hard? If you add an investor in most states, above many of the states, especially medical, and that investor is going to get more than 1% of your business, that needs regulatory approval. That needs background checks. That needs badging. It can take months to be able to get that across the line. Contracts. This seems boring. This is important, people. There are still courts out there. You go to them with a valid contract. And I'm happy to send this to anybody, by the way. I'm fairly proud of it. I looked at a bunch. I didn't like any of them, so I drafted my own. There are many courts out there that are to this day saying that cannabis contracts are not enforceable. That means you have a deal with an investor. That means you have a deal to buy something from somebody, and they come and say, no, screw you. I'm not paying. I'm not giving you what you paid me for. You go to court to try to enforce that. The court will say, sorry, this is a contract. This is an illegal contract. This is a contract for illegal products, and we're not going to enforce it. And they'll kick you out of court. So I do stuff like this to try to protect ourselves, that say the parties know this is a cannabis relating to a contract relating to cannabis, and illegality is not a defense to enforcement. Does it work? Haven't tried it yet, but it's better than nothing. But you got to think about that, right? Like, these are the things that no other industry needs to worry about, that the court is going to kick you out with an otherwise valid contract. And I'll tell you what, this sounds hypothetical. This is very, very real. We have had, from a procurement department, we'll have vendors, cleaners, toilet paper suppliers, forgetting like the outside of the capsules for your actual product, and everything's hunky-dory, and all of a sudden they say, no, you're cannabis, we're not doing this anymore. Like what? Like, we have a contract. Yeah, no, you're cannabis. See you later. Happens a lot. And so you have to be aware of this. You have supply chain disruptions through no fault of your own, but simply people's risk tolerance changes, or they get bought by some multinational that doesn't want exposure to the space. Labor and employment issues, right? Like, we've now 1,200 or 2,500 employees. We were just able to get a 401k in place last September. We've been trying for a long time. A company like ours, growing, trying to provide living wages, trying to provide people with a career, not just a job. And one of those things is helping them plan for their future. We could not find a reputable 401k provider that would work with us until very, very, very recently. You've got people losing bank accounts. You've got, up until not too long ago, people would have their payroll deposit into one bank account and then quickly transfer it out because banks were shutting it down as soon as they realized that payroll was coming from this. So, I mean, these are real life issues where federal illegality and this patchwork really comes into play. Real estate locations, I mean, forget about it. Setbacks, Every state has their own rules. Municipalities have their own rooms. Some towns want to put you over in the industrial area. Like you're trying to operate a dispensary where people are going to feel welcome to come in, and you're sandwiched in between, like a factory and a sex shop, and you can't get somewhere where people are going to be comfortable to show up. You're trying to get into a shopping area. Well, there's a box chain there, Starbucks, Office Depot, and in their leases with the developer, they say no illegal substances, no illegal businesses can be operating there. Oh, we're an illegal business. So all of these things that sound legal and esoteric impact every decision we make as a company and commercially. I mean, just the security components of it. Every state has their own rules. Some towns requires 24-hour armed guards at our dispensary. And this is in addition, of course, that we have Fort Knox's worth of vaults in the back there, reinforced concrete and steel. You still need armed guards and the liability that entails. Some towns, not at all. And it's, again, all of this varies throughout there. So the point of this is that why am I going through this? I'm trying to put this in the back of your head. I'm trying to help you develop those cannabis lenses here. That sort of everything you do in your operations, A to Z, when you are a plant-touching cannabis business, has to be thoughtful. It has to take into account the rules and the regulations of where you're at. So for the last kind of parts, what I want to talk a little bit about is getting into a little bit of these variations at the cannabis specific stuff. Like all of these were like in the background of your business, right? These were all the things that people have to deal with as they're negotiating. Well, what about the cannabis itself, right? How is that provided to people? Well, that varies across all the states as well, right? So I want to talk about a little bit about that, and then some of the things that we've seen in best practices across these different industries, across these different states, hopefully provide what we think are best practices and something for you all to think about as you're working through with your legislature here and the like. So talk quickly a little bit about form factors of cannabis. This came up really, really well, I think, in discussion yesterday. We're talking about the Texas compassionate use program, right? Nope, that's no good here. That's no good here. That's no good here. And the idea is that you've got all these different ways of ingesting and of getting the cannabis, the medicine into your system. And they all have upsides and they all have strengths and they all have some weaknesses, right? So smoking, fastest way to get it into the system, right? Also has kind of the shortest, broadly speaking, quickest effect, and it works its way through your system the quickest. Then you get sort of your gummies, your lozenges, and takes a little bit longer, 30 minutes, up to 2 hours, and it lasts in your system for longer. I think it's pretty obvious if you're trying to get some kinds of pain relief, you probably want that pretty quickly. If you want it long lasting, maybe you want an edible. If you've got lung problems, you're probably not going to smoke. An ingestible might work, a suppository that came up yesterday. But the idea is by what we've seen is a slow move towards allowing the full panoply and a medical first and a medical provider first aspect. In our view, that's very much the best way to be going. It doesn't make a lot of sense to regulate the method which this is done without sort of that medical input here. So we are firm believers in the importance of having this be a medically informed decision, and with that. Going to sort of purchase and possession limits, right? The 1% THC cap here, or that you see in other states, I get where that's coming from. I think the notion is, oh, well, that's a low percentage, so therefore this is low THC. Well, it's not really, right? Like something like this. I did an experiment on Friday. I took my wife's vitamin that she takes every day, and I weighed it on the kitchen scale. So I was really curious. So it's about 2 grams. So what's 1% of 2 grams? It's 20 milligrams, if I did my math right. So 1%, that pill that she takes every day would be 20 milligrams of cannabis. That's a lot. Not a crazy amount, but most dosages, most states are 10 milligrams, 5 milligrams. So it's sort of failed to do what the theory was, and it also just doesn't make a ton of sense. Like if you're allowing flower, how would you be doing that? I mean, then you're effectively smoking hemp, which is fine, nothing against it, but it's not really the same concept here. So again, we think that that's something that should be very much thoughtful and medically driven. Qualifying conditions, again, there's a spectrum here, right? We've got Texas, enumerated qualifying conditions, a little bit of flexibility around the incurable neurological issues, but at the same time, it's these and only these. And then on the other end of the spectrum, you have where New York just did, and New York just came out with any condition that a qualified medical provider basically believes that or assesses that cannabis is going to be helpful for them. And within that, you've got a range of different things. I think, for Texas, a nascent state, something that we've seen that works well, we think is in Ohio, where Ohio has, there was a legislative list like here, and then the Board of Pharmacy that regulates cannabis, they have the ability, they have a medical advisory board that they're able to make updates to the qualifying list condition. And so it gives you that flexibility, especially in a state like Texas, where your legislature is only meeting every 2 years. And so to add something is a big to do, right? How hard was getting PTSD added? Very important and very difficult. This gives sort of a little bit of that flexibility while letting the legislature still feel that they have control over the process. So we think that that works pretty well. There's so many things, but I'll move a little bit just because I feel bad. Advertising, I think really important. You've got, right, like something like this. Basically, this is the way that you can maybe get on Instagram, because otherwise they're going to shut you down if you show flower. And many states have kind of similar rules. And I mean, I just love this little example. This was the same marketing campaign at the same time. And you just see sort of this stark difference between how different states treat your advertising, right? Like Pennsylvania must be your medical marijuana store. Dispensary, actually show pictures, actually show people that maybe get some use and benefit. And so we think that that's, it's just important to sort of pay attention for that. All right, so for all of this, recap this part right now, between federal illegality, state patchwork, the fact that this is still a pretty new industry, at least with state sanction. What are some of the things that we've seen that have worked for us? And honestly, I will tell you, it really comes down to kind of compliance, right? Because being a lawyer in this industry, it's like being a lawyer anywhere else, but it's like you're underwater, like with weights on you and your hands tied behind your back, because everything's a little more difficult. And so what we think is, this is how we're structured. And I don't think that everyone has to do it this way, but I think this is kind of the concept. And the concept is, when you're thinking legal, or you're thinking operations, or you're thinking anything like that, you want legal. You want someone like me and my team, and our job is to get those contracts drafted. Our job is to defend those lawsuits. But we need to be always aware of compliance. We always need to be aware of what the rules and regulations are currently saying, and making sure we stay within that. And then you want your government affairs. Now, that doesn't mean lobbying always. That means keeping an eye on what's coming down. What's up? You don't want to get blindsided by a total change in regulations, right? It could be working its way through the legislature or through the regulatory agency for 6 months, and there's lots of chatter about it, and then all of a sudden it happens. You're like, oh, I'm surprised. I had no idea that was coming. If you're paying attention, you'll almost always see it's coming. Unless it's New York with the new conditional use cannabis growers, which is kind of caught everyone a little bit by surprise, I think. So to kind of try to do this, I'm running out of time, aren't I, Heather? Okay. I was going to talk about a little bit the legacy of criminalization and what we can do. I will be very short about this because I think this is incredibly important to talk about. But basically, right now, what we have is we have a state-sanctioned market industry that is massive and only growing. So I think it's incumbent upon us, companies like us, companies that are out there, that it's incredibly important that we do what we can to get people, especially those disproportionately impacted by the war on drugs, that we help people, provide them training and true careers. So what I would be showing, this is wild to me, right? So this would have been a video about our partnership with a local community college where we have given them, I think it's $700,000 to date. We've helped them stand up sort of a craft cultivation. One of my team gives a lecture every quarter. We've got lots of people that are out there. We provide internships, and we provide people without means, right, to get into this industry and have true careers in this. Again, 401k, benefits. We've got unions in 2 states, and that's increasing. I don't want to downplay that. I'm just running out of time, and I want to make sure I have a little bit of time. So finally, why am I here in Texas today? Second biggest state. I'm from Alaska originally. I'm going to remind you, it's second biggest population and in size. I've got to cut Alaska in half. Texas is the 3rd biggest state. Did you know that? It's a what's that? Sorry. But it's a bellwether for national sentiment, right? Like if we get to the point where Texas and California agree on something, writing's kind of on the wall for the rest of the country, right? So we're here and we've been partnering with people in the state to try to kind of help provide some of our expertise in these early medical markets and try to give a little bit of some of these best practices. I think, it's all about education. We think the dispensary model is a good one. We think it's like an old school pharmacy where you have the chance to go and you talk to your pharmacist like it used to be. And you have the opportunity to learn more, the opportunity to tweak, you have the opportunity to safe and efficient pickup of your medicine. We think that a medical first approach towards form factors, as we discussed, towards qualifying conditions. And then finally, we think it's really important to really build out your infrastructure around safety, around efficacy, and around quality. We think that third-party testing is really, really important, and that you need a robust infrastructure for all that. So with that, things I want everyone to take away: remember this complexity of federal versus state, keep those cannabis lenses on, and we think that doctors know best. And thank you very much. Oh, it's up to you. I apologize. Yeah, please.
So I know that the Safe Banking Act was accepted into the spending bill and is moving along. Have you got any new updates on if there will be any traction on that, and if so, when that might be? And follow up, Schumer's bill at the federal level that he's talking about dropping in April. Any insight on that?
Again, I will caveat this that I'm the guy working with what I have right now. The scuttlebutt that I've heard is that safe banking not likely to make it through this time, unfortunately. The CAOA, Schumer's bill, might be nice. I haven't heard a lot of optimism there, unfortunately. I think it'd be great. I think it'd be wonderful, but again, I have no particular insight other than reading and kind of following up, but it doesn't seem like it's got a great shot, unfortunately. I think everybody's kind of waiting to see as we get closer to midterms, maybe something, but there's just so much maneuvering, right? With Representative Mace dropping, kind of with her talk right now. So you've just got these maneuvering where everybody's kind of trying to jockey for position between the Democrats and the Republicans. Who's going to kind of own this? Who's going to get ahead of this? Yeah, I just don't, and nobody knows. I haven't heard anybody who's like, oh, this is a good. Yeah, I don't.
Okay, let's do one more question.
Oh, yeah.
Anybody who wants a quick question? Okay. Is this hot? Can you hear me? Okay, good.
Thanks, Heather. I actually would ask you please to expand a little more on that last part of your presentation about the small businesses and minority and women-owned businesses and what PharmaCann is doing, because as I'm sure you're aware, and the Texas landscape is really built for MSOs, and a lot of the states in the South are being built, their framework is around MSOs and the success of MSOs and not really so much geared towards small businesses. And there's not a lot of social equity programming in the South. So what is PharmaCann doing, if any, and what do you see other MSOs doing in the private side to help where the government and the social equity programs have not been successful?
Yeah, great question, obviously. I will start that I think for right now, I think that I'll be perfectly honest, in my view, one of the biggest issues with kind of true social equity and truly allowing small businesses to thrive right now is kind of that patchwork that I was talking about. It's that federal illegality. I think the lack of safe banking is perhaps one of the biggest issues right now, right? Like big companies, like we're able to get banked, right? We're able to raise money. Who can't? If you're trying to start a ma and pa shop, and the fact that you can't go and get a small business loan, the fact that you can't get a business credit card, I think it is absolutely prohibitive. I mean, the cost of compliance for dealing with all of these is astronomical, right? Like the difficulty in getting a license, the fees in some states, I think are, I'll be honest, I think those are the biggest problem and the biggest hindrance for social equity right now. What do we do? I can't speak for anybody else. I know what we do. We have been incubating multiple social equity license first in the application process, and now some of them luckily got app licenses. We'll see if they get awarded in Illinois. It's a little bit nuts, but we've continued long past sort of our obligation, and we're providing them with mentorship. We gave them jobs so they could learn the business from the inside with us while they were waiting to find out if they were gonna get those licenses. And we're helping actually build them up to do that. I think what I wanted to talk about a little bit, and I apologize for that, is we've got Oakton Community College in the Chicago area. We have basically founded and funded their cannabis like study group. Like you can go there and get a degree in this. And that's like a real thing. Like we've helped them get to the point where they can actually grow cannabis as part of their product. We've got one of my team members, she teaches a class there. We've got multiple people that are there and providing guidance and doing all that. So, you know, I don't think it's our business necessarily it's our business to expand the pie. I think it's our business to help do what we can to provide those training. Like the way I think about this is you're gonna have your Starbucks, you're gonna have your corner coffee shops. You're gonna have that for cannabis too, right? And I think that this is a large ecosystem and there's lots of room, and we're doing what we can to help mentor those entrepreneurs. But frankly, the problem isn't us necessarily, right? The problem are these rules and regulations that make it impossible to operate if you don't have a legal team, if you don't have a compliance team. Like I just don't know how you can even do that given the way that things are structured right now. And that's where I think a lot of the difficulty comes in.
And social equity is so important, and it's wonderful to see industry leaders like y'all doing just that. We're going to share the video if you'll send it to me to everyone and share it out so we can see the good work that y'all are doing. But big thanks to you, Mayor
Thank you very much.
Grashin, for joining us with PharmaCann.